If able, you can file your temporary restraining order at your county courthouse between the hours of 8:30 a.m. and 3:30 p.m. You may go to the county where you live, where the abuser lives, where the incident occurred, or to where you have fled. Once you arrive at the courthouse, you should locate the family intake unit that issues temporary restraining orders. If you require protection from an abuser outside of 8:30 a.m. to 3:30 p.m., on a weekend, or if you are experiencing an emergency, you may seek a temporary restraining order from your local police station, or the police station where the incident occurred, where the abuser lives, or to where you have fled. The police are not supposed to make you wait until Monday morning to go to the Superior Court and file a complaint. You should be assisted right away. They are also not supposed to tell you that you do not have a case or are not a victim of domestic violence. This decision is to be made by the municipal court judge. No matter where you file for your restraining order, you will need to fill out paperwork and provide information about yourself, including where you and the abuser live and work. You will need to explain what your relationship is to the abuser and disclose whether you share any children. You must also explain why you are seeking a temporary restraining order. What happened between you and the abuser that caused you to seek the protection of a temporary restraining order? In addition to the most recent incident of domestic violence, you will be questioned about the history of domestic violence. It is important that you disclose incidents that have been reported and unreported. Think about any prior incidents for which you may have obtained a temporary restraining order, or an incident where there were witnesses or other evidence, though these are not required. It is important to remember that pushing, slapping, constantly calling, and name-calling can be included in a history of domestic violence. You will only be able to testify about incidents outlined in your temporary restraining order, so it is important to be thorough in your order. At the time you file for a temporary restraining order, you can request possession of a car, emergency support, custody of shared children, and any other assistance you may need until a final hearing is scheduled. You should also tell the staff if the abuser possesses a weapon. A search warrant can be issued to remove possession of that weapon from the abuser. After you provide this information, a temporary restraining order complaint will be drafted. It is very important for you to review this document in its entirety for accuracy. If any of the contents are incorrect, you should ask for a correction. Once the temporary restraining order complaint is correct, you will sign page 1 of the document. Once the temporary restraining order complaint has been created, you will have to speak to a judge or a domestic violence hearing officer about your domestic violence situation. That is, the information contained in your temporary restraining order complaint. If you are filing your complaint at a police station, this conversation may happen over the phone. Whether in person or over the phone, the judge will ask you questions during this conversation, and it is important to answer the question directly and be honest. If the judge determines you have a case for domestic violence, he will grant you a temporary restraining order that day. If you are denied a TRO from a domestic violence hearing officer, you may request an immediate appeal in front of a superior court judge. If you need more time to prepare your case, gather evidence, or find an attorney, you may request an adjournment to your case.
If you need legal advice or representation, you can see if you are eligible for our services by calling 1-888-LSNJ-LAW or completing our online intake at www.lsnjlawhotline.org.